Ready? Good morning, ladies and gentlemen of the media. Today we have finally concluded this long and historic journey of a national recount of the ballots cast at the March the 2nd regional and general elections. It is historic in the sense that it is the first time we have had an exercise like this conducted in Guyana, in the Caribbean, and perhaps the entire British Commonwealth. And it has been a journey plagued with many difficulties, and you are aware of it. You are aware of the basis upon which it evolved. You are aware of the various hurdles that we had to cross before we arrived at this final destination. Today, the most important component of the exercise would have concluded, and that is the physical recount of the ballots. Our presidential candidate spoke with you. The General Secretary spoke with you last night as well. And I would like to reiterate the gratitude that they would have expressed to all those persons who would have worked here tirelessly to make this exercise a success, and also to thank you, members of the media, thank all the political parties, thank the international community, thank the staff of GCOM, thank the people of Guyana for their patience, and thank all those who would have contributed to the peaceful and orderly conduct of this exercise. This exercise demonstrates that democracy and the rule of law are still alive and prevailing in our country, despite attempts to derail the democratic process, despite attempts to thwart the will of the people. What we saw with the conclusion of this exercise is that good triumphed over evil. What we saw was the rule of law prevailing over anarchy, and democracy prevailing over thuggery. And this connotes a great victory for our people, all of our people, and of course Guyana. Needless to say that the exercise is far from completed. There are more components which are to be undertaken and executed in accordance with the law and in accordance with the order executed by GCOM and which governs the exercise. As you are aware, upon the completion of the tabulation, the Chief Elections Officer is required to prepare two reports. One is a summary of the observation reports, and a second one is a summary of the numbers which would have been extracted from the SORs, tabulated, and which would be on the certificates in relation to the 10 regions. So the order does not provide for the CEO to have any personal subjective input. He is simply to summarize the observation report and tabulate, aggregate, and total the numbers which would have been tabulated and which would have been put on the certificate, constituting the declaration of results for each of the region. There is no place, I want to emphasize, for the Chief Elections Officer to inject a personal opinion, to offer any recommendation of any sort whatsoever. His duty and role in the letter and spirit of the order is quite mechanical and straightforward. When he presents that report, and he has to do so on or before the 13th of June, and upon the presentation of that report, then the commission will have to deliberate on the report. In their deliberation, I suspect that they will have to check the numbers and ensure that the observation reports were summarized accurately, and then check back the tabulation of the numbers, and then declare a result based upon the report presented by Mr. Lowenfield. And it's upon the declaration of that result that the party whose presidential candidate received the most votes would be declared the president and deemed to be the president of the Cooperative Republic of Guyana. Having regard to the numbers that you are all aware of, the political party and the presidential candidate that ought to be declared and is expected to be declared is Dr. Mohammed Irfan Ali, and the People's Progressive Party being the party for which he was the presidential candidate. And you are very well aware of the margin of victory, over 15,000 votes. So the recount has confirmed in every material way that the statements of poll, one by one, that the PPP made public from the inception, the statements of recount corroborated, supported, and confirmed the figures contained in those SORs, in every SOPs, in every material way. And the fraud perpetrated by Mingo and condemned by all the observer teams and condemned by the world, that fraud has been established beyond a shadow of doubt, whereby Claimant Mingo, the returning officer of Region 4, inflated votes by tens of thousands and gifted them to APNU, while at the same time deflated votes of the People's Progressive Party. And that has been established beyond any shadow of a doubt. So, with the conclusion of this exercise, this component of the exercise, it is expected that the two other components that are remaining would be concluded orderly and in the letter and spirit of both the order, the Constitution, and the Representation of the People Act, which is the legal landscape that underpin this exercise. And it is expected that it will conclude smoothly. This country has been under tremendous tension over the past 3 months, and I don't think that any one of us would want our country to remain in this state that it is in. It's not in a healthy state, and we need to get a legitimate government installed as soon as possible. We are already in excess of 3 months late in that respect. So I hope, and it is the country's expectation, and indeed the region and the world's expectation, that the chairperson and GCOM would discharge their oath of office and deliver fair and credible results as tabulated and produced by the National Recount exercise. So I will stop there with those brief remarks, and if you have any questions for me, I am prepared to answer them, or at least try to answer them.
Is there any possibility for GCOM to pronounce and say that the electoral process was not credible and therefore they can't be the results based on the outcome of this exercise?
We have repeatedly stated that the recount is an is a legal exercise. It's an exercise that is governed by principles of law. And there are things that can be done in a recount exercise and things which cannot be done. So GCOM lawfully has no jurisdiction, no power, no authority to pronounce upon credibility, legality, or validity of its process. That's the first thing. In any event, by the principle of natural justice, one cannot be a judge in one's own cause. GCOM cannot judge itself. And thirdly, the issue is not without provision in the law. The Constitution of Guyana, Article 163, resides exclusively, and note the word exclusively. The Constitution itself uses that word. It resides exclusively in the High Court, a jurisdiction and a power to deal with issues of credibility of an elections, omissions, and allegations of wrongdoing emanating from an election. So, to answer your question, no. GCOM has no power and no authority to embark on any such exercise. GCOM is bound by a recount is a numbers game. It's a numbers game. It's a recount of what was counted on election night. Hence the term recount. What was done on election night were the ballots counted. And a recount of that is simply a redo of that process. So it is a count back of that which was counted by the presiding officers on election night. GCOM has no mandate at a recount to do anything outside of that.
Is it your understanding based on the gazetted order that the results have to be declared 3 days after receiving that report, or on June 16th, sorry, or by June 16th?
Lowenfield has on or before the 13th. So he can submit it before the 13th, either on the 13th or any day before that. And once it is submitted, they have 72 hours, 3 days thereafter. So if he submits it on the 12th, they have to submit by the 15th or make the declaration by the 15th. So it's a 3-day they have after receipt of the report from Lowenfield or the reports from Lowenfield.
As the known legal mind of the DOJ, are you anticipating any court action challenging the results from the recount?
There should be no court action because, at least not challenging the results before the declaration. We have heard about allegations being made. They are all public and they form part of the process. And I have articulated very expansively before this tribunal that those are matters that ought to form the subject of an elections petition and present to a election court by the proper procedure once the declaration of the results are made. But in terms of actions filing before, ante the declaration, I do not anticipate any serious action can be filed. Now, anyone can file anything. Whether it will succeed is a completely different matter. I don't think you can stop anyone from filing any action. But certainly, one filed before that seeks to stop the declaration or seek to impugn the results produced by the national recount exercise prior to the declaration of the results and not by an election petition would, in my humble view, be a misconceived use of the legal process.
Mr. Nandlall, CARICOM is expected to submit a report. Do you think the Commission should await that report before deciding on whether it will proceed to, how it will advise the CEO? And do you think that report could impact the decision of the Commission?
I can only advise myself based upon what GCOM has bound itself to. and a clear examination of the order and its addendum. Once that is examined, you will come to the conclusion that it does not provide for GCOM to await any order, any report from CARICOM. You will know that GCOM crafted that order, and then it did not have that in it. That is absent. Then GCOM did an addendum at which there was a full meeting and deliberation, and were it to be included, GCOM was free at the stage of the addendum to amend the order to include the incorporation of a report from the CARICOM team. GCOM chose not to do so. So I cannot imagine that GCOM would want to await some report from CARICOM when the order doesn't provide. The order speaks very clearly and in mandatory fashion to the process by which GCOM is to conclude this exercise. And nowhere in that procedure is there a provision for CARICOM report to form part of the process ante the declaration. Perhaps at some stage, post the declaration, GCOM can have the CARICOM report, but speaking based upon the literal and clear language of the order, the order does not permit and does not allow GCOM to await any such report from CARICOM.
Sir, am I understanding that you're saying a probe cannot be done before the declaration of results? First question. Secondly,
A what?
a probe, an investigation.
A probe,
into allegations of fraud cannot be done before the declaration is made. Secondly, we had campaign manager Joseph Harmon saying that should no fraudulent votes be counted, the APNU AFC would win the election. What are your sentiments concerning that?
As I have said perhaps over 1 million times, a recount exercise is not a matter of guesswork. It's not a matter of conjecture. It's a legal process. Election on the whole is a statutory exercise. Every component from the registration of a voter to the declaration of the final results, every component in that chain, every link in that chain is the subject of an express provision in a statute. Included in that statutory network is a recount process. That recount process makes no allowance by statute for any probe of any kind to be done in relation to fraud. And GCOM, as the body authorized exclusively to execute, manage, and supervise the election, was never vested with the power in law to carry out that exercise. It is not that the law did not contemplate such occurrence or the existence of allegations of that type. The law does contemplate it, and the law makes explicit and elaborate provisions for it. And Article 163 of the Constitution is the vehicle that takes you along that path in collaboration with an act called the National Assembly Validity of Elections Act. And the combination of the Constitution and that piece of legislation compendiously contain all the principles in respect of how allegations in relation to wrongdoings and fraud are to be treated in relation to an election. The rationale behind it is because you're dealing with the election of a government of a country and you are dealing with the election of representatives of people in a parliament. The parliament and the government is what run a country. And the law will never countenance any great delay in relation to the installation of a new government after an election. It is for that reason that the law did not provide and does not provide for any great period of dilation and procrastination during election time. Election is a fluid process. If you have a problem with it, you go to the election code, but the government who has won the elections based upon the ballots cast must be installed, and installed in the quickest possible time. An election petition, for example, is the only type of litigation that the law says must be conducted on a day-to-day basis. Of course, in Guyana, unfortunately, it's a different reality because you know we filed an election petition since 2015 that has not yet been heard, and we have gone to another election. So I say that to you to tell you that the law is not in doubt about these matters. And lawyers know this. Mr. Harman ought to know this. This is an area of law that is common throughout the Commonwealth. Anywhere where the British legal system was implanted, Britain put into those legal system their system of government that they had in England for 1,000 years before. And that's the system that we have throughout the Caribbean and the British Commonwealth. It's no different in these countries. So that's your first question. What's the second one?
Mr. Joseph Harman saying that should no fraudulent votes be counted, the coalition government...
Mr. Harman is mixing up a fraudulent allegation with an establishment of fraud. Now I know you're going to ask me about Mingo. And I keep telling you that Mingo, I saw Mingo fraud. This recount exercise has established Mingo fraud. Mingo fraud is not in doubt. Nobody, Mr. Harman, is yet to establish. In all the allegations he has made, is yet to connect a single one with a ballot in the ballot box. And he can't do it. The exercise here will never allow it to be done. It has to be done in a court. So Mr. Harman's contention remains allegations. The same allegations that people have. In every election there are allegations. In Trinidad, when the last election was concluded, they had 6 elections petitions that were heard and determined within 9 months in Trinidad. That system functioned. So it is not that you will not have irregularities, and all the CARICOM, Mia Motley, the Honorable Prime Minister of Barbados, spoke to that in her statement. OAS recently spoke to that in their statement. They identify with the irregularities that have been made or alleged. Because it's not unique to Guyana, but we can't equate allegation with the establishment of the phenomenon. And you can only establish the phenomenon before a tribunal established by law, where there is a process that allows you to prove fraud. The right to vote is a fundamental right guaranteed by the laws of this country. The other day they had an incident on the East Coast involving some 7,000 votes. Those 7,000 voters did no wrong. They were afforded a right by the law to cast a ballot. They entered the polling station and they cast that ballot. That ballot was counted elections night and tabulated, and the SOP was prepared. No irregularity whatsoever. Some returning officer bungled up their duties and put papers where papers were not supposed to be put, and excluded, refused to put or omitted to put papers where they were supposed to be. How? By which system of law or logic would you invalidate those voters' votes when they have committed not a single wrong and they are exercising a right? And nobody at GCOM can do anything about it because they have to be heard. Every single voter. Because at least, you never, natural justice says that you cannot take a man's right away without hearing him or affording him a fair hearing, which includes allowing him to be represented by a lawyer of his choice before a tribunal established by law to hear and determine his complaint. GCOM is not equipped with that wherewithal. It is as simple as that. So Harmon knows the right thing. Harmon is a lawyer of over 25 years standing. Harmon is playing politics. Roysdale Ford knows the right thing. Basil Williams, I hope he knows the right thing. We practice this law all the time together. They were in Esther Pereira case. They won the case. They didn't win it at GCOM. They had to go to the High Court. You hear the boast how they win Esther Pereira case? Well, they had to go to the High Court by an election petition after the elections and prove all those things. And they didn't win by proving it either in Esther Pereira case. They won on a technicality with the law that provided for voters' ID card, but that's a different matter. But I just give you that example to show you that they know the right thing. They all appeared in those cases. So what they're Harmon them coming here and do is politics. But I have a problem when lawyers trample upon the law for political gains. That should not be done. Law is what governs a society. A nation is governed by laws, not men.
Mr. Nandlall, you made reference to the East Coast case in which the documents were missing from the 29 ballot boxes. You said the voters did nothing wrong. How do you view the case in Sophia and other similar cases in which it was alleged that the presiding officer stopped the ballot papers incorrectly?
Yeah, let me deal with that. I dealt with it before. I know what you're going to ask me. And I said to you that there is one exception to the rule. The rule is every authorized ballot must be counted. Authorized ballot. In that case, it was not authorized because and yes, it's not the fault of the voter, and that's unfortunate. And the APNU lost 40 votes. The PPP suffered worse at Pindola Primary School, where we lost 102 votes because of no fault of the voter, because the presiding officer did not stamp the ballot. And we accepted the principle because it's one rule which governs the game. It's not one rule for one party and one rule for another party. So we lost that 102 votes.
But regardless of the size, would you say that the electorate or the voters within those blocks were disenfranchised, given the fact that for the regional part of the same ballot paper, it was stamped, but for general, the votes were...
Yeah, I understand. It's a sad situation.
Okay.
It's a sad situation, but at the end of the day, the law is the law and the law shall prevail. Any other question? Thank you very much.